The Supreme Court today questioned the central agencies, that is the CBI and the ED, over the slow pace of trial against Christian Michel James, the alleged middleman in the AgustaWestland chopper case. The bench, comprising of Chief Justice of India D.Y. Chandrachud, was hearing the bail plea of Christian Michel's bail plea, which was earlier dismissed by Delhi High Court in March this year. During the hearing, the bench inquired whether it was appropriate to deprive Michel of his liberty simply because he was a foreign national. The apex court also questioned the slow trial against Michel and stated that had Michel been an Indian, he would have been granted bail in these circumstances. Remember, the two investigating agencies have lodged two separate cases in connection with the case. The top court has posted the matter for hearing in the second week of January 2023. Let's take a look at the timeline once again that was running just now to give our viewers an understanding on the exact backdrop of this case. Now, this is with regards to the AgustaWestland bribery case. As viewers would recall, CEO Bruno Spagnolini was arrested in Italy on bribery charges in the AgustaWestland helicopter case, and that is what sparked off the inquiry in India. With March 20th, 2015, ED attached assets worth 1.1 crore of British national Christian Michel James. In November 2015, Interpol sent a red corner notice against Michel. December 9th, 2016 is when CBI arrested former Indian Air Force Chief S.P. Tyagi, his cousin Sanjeev Tyagi, and lawyer Gautam Khaitan. February 2017, UAE authorities arrested Christian Michel. He was found to be based in UAE, where the Dubai authorities arrested him. CBI requested for his extradition, and September 2017 is when CBI filed a charge sheet against S.P. Tyagi and 11 others. July 2018, ED filed a charge sheet against 34 accused, and in November 2018, the court proceedings on the extradition concluded in UAE, following which in December 2018, Christian Michel was brought to India on a special plane. That is how the extradition process started. And with that, Michel was kept in jail. His bail plea was dismissed by the High Court earlier in December 6th this year. In fact, that dismissal was challenged in the top court, the hearing of which was done today, and the next date for hearing has been now kept for second week of January. Well, joining us here on the program are two legal luminaries, experts who will give us an understanding of this particular issue on what happens when there's a foreign national involved in a case like this. Let me welcome Mr. Sanjay Hegde, senior advocate from the Supreme Court, and Namit Saxena, again a senior advocate, joins us here on the program. Very good evening, gentlemen. Thanks for being here with us. I want to begin by asking you, Mr. Hegde, that the bench has clearly inquired if it was appropriate to completely deprive Christian Michel of his liberty simply because he was a foreign national. The counsels have been asked to submit a note. As it turns out, there is a grey area. It seems there is a conflict between what is in the statute and what is in the treaty. Is Christian Michel having to languish in jail owing to this ambiguity, Mr. Hegde?
Well, he's languishing in jail because the courts have not granted him bail. One of the factors is that he's a foreign national. But despite being a foreign national, there is no reason not to grant him bail as long as you can secure his presence at the trial. So while there is a certain conflation in the prosecution case that he's a foreign national, he can flee and then we can't get him back. There can be adequate safeguards that you obviously have the man's passport. You have you can require him to report at a police station, or you even these days you can electronically track a person. There is no reason why he has to be in the continued custody in jail, pending a trial which is not taking off. And at the end of the trial, if he is supposed to serve only 4 years, he spent more than that time already in an Indian prison. The real problem with the Indian criminal justice system is the police's ability to throw people in jail, forget about the trial, and oppose bail under all circumstances in all courts.
That is a fair point. But again, you know, Namit Saxena, would it be fair here to quote what the defendant had said? Because the defendant has argued that a fugitive can only be tried for offences mentioned in the extradition treaty. He says, I've been charged under sections, if I'm not mistaken, 120B and 415 as well as 420. And there is no mention of Section 8 of POCA, but it is also extracted. This is what the defense is arguing. If that is the case, if that is the logic that is being presented, what the defense is also saying is that they've been extradited for an offense which is punished with 5 years, including remission, which has been completed, apparently, by Christian Michel. Shouldn't he be a free man anyway?
See, what they're primarily arguing is that because he was extradited only under Section 8 of the Prevention of Corruption Act, along with 120. See, 120B is only criminal conspiracy because there are more than 2 people involved. So there's meeting of minds. So there's a criminal conspiracy committed by more than 2 people. But Christian Michel is also charged under Section 467 IPC. He may not have been extradited under Section 467, but he's charged under 467, and 467 says maximum punishment up to life imprisonment. So this argument of Section 436A that I've completed more than half of the punishment, half of the maximum punishment prescribed for the offences under which I'm extradited is not the valid, the correct proposition of law, because he's charged under 467 as well. So he's facing trial under Section 467 IPC also, along with the Prevention of Corruption Act provisions. So, I think this argument may not, be very solid for grant of bail. But if we see it otherwise also, see the purpose of, keeping somebody under incarceration during trial is that his presence is secure during trial. Now, this accused being a fugitive, he had to be extradited from another country. So there are high probabilities that he runs away to some other country and may not be available to face trial. That is why, the prosecution, the CBI is objecting that, please don't grant him bail at this stage. The trial is yet to, flow properly. In case he's released on bail right now, he may tamper evidence. He may, try to, approach witnesses. He may not be available. He may not even make himself available for the trial. So that is why to secure his presence, his custody is required at this stage.
Mr. Saxena, can the trial happen in India? It seems there's no clarity on that also. Even that is something which is argued about whether there can be a trial for Mr. Christian Michel in India. Can there be one?
It depends on, that is again sub judice. It has been argued in different forums. But, what we are concerned today is that whether nationality of a particular accused can be the sole reason for, either refusing bail or for grant of bail. So, all these prove that whether trial can take place or not, this is, a different aspect altogether that is being adjudicated separately. But, but right now he's under incarceration in certain provisions. Whether he should be released on bail at this stage or not is what the court is concerned with, because his bail has been refused by the High Court.
Mr. Hegre, what is the best case scenario for Mr. Christian Michel under the circumstances? Because the argument is being turned around and said, just by virtue of being a foreigner, why should he be granted bail? If nationality is a factor or shouldn't be a factor in a case like this?
Just because he's a foreigner, will you keep him in jail indefinitely and not have a trial at all? And this is the standard prosecution trick
trial or
everywhere.
Not, sir?
I'm sorry?
Can there be a trial in this case in India for Mr. Christian Michel?
I don't see a problem. Well, his defense team has chosen to take that point. I think now, as far as the defense is concerned, they might be better off having a trial, because at the end of the day, if he is going to be sentenced to 5 years, 6 years, I do not know of any forgery case where there has been a life sentence. It is there on the statute books, but rarely is anybody given a life sentence in a forgery case, which is 467. So a speedy trial is in the interest of everyone. I do not know whether his defense will agree to it, but you cannot indefinitely incarcerate people. Whether it's Christian Michel or Umar Khalid and the rest, the basic problem now is that the police have the feeling that if they lock up people, they can just throw away the keys and the courts will look the other way. The courts are getting tired of it. And the courts are getting tired of being the whipping boys as far as failure to secure individual liberty is concerned. We have a constitution which says that, liberty can be taken away only by due process of law, and that due process has to be fair, just, and non-arbitrary. You cannot indefinitely keep people under control, whether they are foreigners or Indians.
Fair point again, and if I may just quote what the defense has said in court today on behalf of Mr. Michel, where he says, I've been arrested and brought to India on the 4th of December. Charge sheets have been filed. More than 1,280 documents need to be examined. Trial is under 207, Section 207 CRPC stage since last many years. It's so voluminous that CBI has not filed before court. So the process of verification of unrelied documents is going on. It is unlikely that the trial will proceed in the next few years. So like Mr. Hegre says, until such time is the man supposed to be behind bars. The investigation has been going on for more than 9 years. In 2023, it will finish 10 years. So for an offence that mandates 5 years imprisonment, the man, should he be in jail for 10 years? We leave it at that. Thank you so much, Mr. Namit Saxena and Mr. Sanjay Hegre, for joining us here on the program.